Your Ladyships and your Lordship received, I hope, an agreed timetable.
We did. I've got to say, speaking for myself, it looks to me to be rather leisurely. And I say that having done the pre-reading, thank you. There are obviously certain parts of the appeal that will need more attention than others. And we are obviously going to seek your assistance on some of the quandaries of equitable compensation. But you can take it that we have done quite a lot of pre-reading.
I'm grateful for that indication. I hear what your Ladyship says, but the idea is you'll hear from me today. Obviously, if I finish before the end of the day, so much the better.
Very much so. But if necessary, we will move you on from certain points.
Yes, of course.
All right. All right. But may I just say thank you very much for the list of essential reading. We've all read the skeletons, both for the appeal and the cross-appeal, and we've had the opportunity to look at some of the authorities that were included on the pre-reading list.
I'm grateful.
So thank you very much for that.
That will speed things up.
Yes. But perhaps you'd like to introduce your...
Yes, I appear for Mr. Davies. My learned friends, Mr. Cook and Mr. Kessler, appear for GBRK and Mr. Monks.
Yeah.
I'd like to open my appeal by making some broad points about the outcome. And I don't shy away from saying that the outcome is very surprising. The judgment of Mr. Holland, if it is upheld, is frankly good news for dishonest directors, because the clear message is this. If you want to divert business, don't take it yourself, because you'll be accountable in equity. Divert it to another person, your company, a business associate, your husband, your wife, whoever. If you divert it to another person, that person will not be accountable. And the reason for that is that what Mr. Holland held was that a knowing recipient can only be liable in respect of pre-existing trust property. So if the director is a director of company A and he dishonestly diverts business to company B is not liable as a knowing recipient in respect of new customer contracts entered into by company B, simply because those contracts were never the property of company A. So we say that that is a surprising, to put it mildly, conclusion, and it is contrary to authority. It is contrary in particular to the decision of Buller and Buller, a decision of this court.
Well, what about the more recent decision in the Byers case? I thought that's dead against you on this point.
Well, Byers, my lord, of course I accept that what Byers establishes that you need receipt. I don't quibble with the idea that a knowing recipient must receive something. I certainly accept that. That's the decision of this court. But the bit I certainly do quibble with is the idea that it has to be existing trust property which is moved across. It is clear in my submission from Buller and Buller, but not just that case, but also from Cook and Deeks, that if business is diverted to a newco, the contract which is entered into by newco is trust property. It's impressed with a trust from the moment it is entered into. And so, my lord, so respectfully, my answer to your question is no. I recognise that one needs receipt, but the question is, where do you get it from? What I don't accept is that it's got to be pre-existing trust property moving from old co to new co.
But doesn't it have to be property in some recognisable sense? I mean, there's an issue as to whether a business opportunity really counts as property.
Well, I mean, certainly before Buller and Buller, sort of the case in the late 90s, like Satnam and so, I'm sure Lordship's seen them, an opportunity was regarded as akin to property for the purposes of founding accessory liability. But in Buller and Buller, Lord Justice Jonathan Parker rather put that to bed, and he said this isn't about, it's not about the important, it is a mistake to focus on the question of pre-existing property. The question simply is whether the fiduciary is in a position of conflict, and if the fiduciary is in a position of conflict and causes an opportunity to be taken by another company, then the consequence of that is that what is taken by the new co is held in equity. And you will have seen, I've dealt with this in my skeleton, but what my learned friend says about Buller and Buller is that he says that's a case on unfair prejudice. So this isn't the general law, if you like. This is a special jurisdiction. I don't accept that. I hope your ladyships and your lordship have had a chance to read the FHR case, which I rely on heavily. That was a case about bribes. That's the question of equitable remedies which were available as a matter of general law. The Supreme Court relied on Buller and Buller, so it's not just an unfair prejudice case. It represents it is a statement of the remedies which were available as a matter of the general law if an opportunity is diverted to a new company.
And you'll be taking us to that
Yes,
authority in due course.
Yes, of course. Yes.
Yes, well, thank you. I was really just putting down a marker. I don't want to take you out.
No. Well, I'd much rather be guided by the court. I don't need to labour this point because you've seen it from the judgments, but I do, by way of initial point, it's important to bear in mind this is a fraud case and we're dealing with the proceeds of fraud. I ask you to bear that firmly in mind when you consider whether the outcome in this case was a just one. The question of fraud is important. We'll come on to I will come on to address the claim for equitable compensation, but I will when I deal with AIB and Redler. One of the things that the Supreme Court made clear is that it wasn't a fraud case. And so whatever that establishes, it's not about fraud. It's not this case. Just sort of by way of outline, on Mr. Holland's findings, what Mr. Monks did here was dishonestly divert a business which he held to be worth 0.8 million. If I could ask you to take up the quantum judgment, which is at tab 17 of bundle 1. Tab 17, if I could ask you to turn first of all to page 288. You see Mr. Holland has included a passage from the cross-examination where Mr. Holland himself asked Mr. Monks some questions. And Mr. Monks accepted that the only difference between GBR, the old co, and GBRK was the difference in Mr. Monks' equity stake. Mr. Monks had a 10% shareholding in GBR and a 50% shareholding in GBRK. That was the only relevant difference between those two companies, and that tells you a lot about what this case is really about. Mr. Monks was motivated to divert business to GBRK because he had a much more significant equity stake in that company. Again, I'm sure your ladyships, your lordship have read this. I don't need to labour it, but I just pick up paragraph 122. Mr. Holland has said that one should take the value of GBRK in 2011 as a proxy for GBR and the business it would have had in the counterfactual world. And then you see the same thing at paragraph 139. GBR would have been in exactly the same position logistically and financially as GBRK was in the real world, at least until October 2011. And then paragraph 155, again the same point in the last sentence, applying the robust manner in which the court is encouraged to adopt in these circumstances in the counterfactual world, and but for Mr. Monk's breach of duty, GBR would in October 2011 have had a business which it could have sold for value.
I mean, so far as I understand it, both sides are content with that approach. I mean, nobody is saying that it was wrong.
Well, subject, so I don't want to anticipate my learned friend's cross appeal, but
subject to the
there is
valuation.
Yes,
I mean,
yes, exactly, yes. And then if I could ask you to turn to paragraph 159, it's where Mr. Holland dealt with the value of GBRK in October 2011. And you're seeing that this is the subject of the cross appeal, but
yes.
Mr. Holland's conclusion at 173 is that the business of GBRK was worth 800,000, and I obviously seek to uphold that on the cross appeal.
Sorry, 173 did you say for the purpose of my notes?
Sorry, yes, page 307.
Yeah.
And so, just to take a step back from this, the position was this: in October 2011, everything which GBRK had, GBR should have had on the judge's findings. So GBR should have had a business worth 0.8 million. It didn't because of Mr. Monk's dishonesty. So what happened in October 2011? Well, you've seen that Mr. Holland's factual conclusion was that GBR would not have been able to trade on beyond that point because GBRK's business in fact ran out of money, and Mr. Monk's needed to raise further equity finance. He raised 98,000 odd from his parents and 200,000 from Mr. Simmons. And you will have seen from the cross appeal that I rely on Mr. Simmons' investment as the best evidence as to the value of GBRK's business. So what Mr. Holland has said is that he brought the curtain down, if you like, in October 2011. He said that the only compensation payable is up until October 2011, because at that stage GBR wouldn't have been able to trade on. So GBRK was only able to trade on as a result of an equity injection of about 300,000. So the consequence of this is that what Mr. Holland has done is given the whole of the upside, the whole of the increase in the value to equity. So to make the same point a different way, what the judge has done is attribute no value to the contribution made by GBR. But in my submission, it's unrealistic and it's wrong in principle, because there were two ingredients needed for GBRK to trade on. Number one, it needed a trading business, and that's what GBR contributed. So GBR contributed 0.8 million. It didn't mean to, it didn't choose to, but that's what was forced on it as a result of Mr. Monk's conduct. On top of that, GBRK needed an equity injection of 0.3 million. Both of those ingredients were necessary. Again, the point can be made, the point can be emphasised in this way. If one asks, what would GBRK have had if GBR had not contributed a business worth 0.8 million? The answer is all GBRK would have had is 300,000 in a bank account. It would have had no business. And yet Mr. Holland, the effect of Mr. Holland's decision on quantum is that the whole of the upside, the whole of the increase in GBRK's value is attributable to the equity injection of 0.3 million. Whereas one might have thought that the appropriate approach is to say, well, is to recognise the equity injection and the 0.8 million in the operating business, they were both necessary. So the profits which were generated by GBRK should be divvied up between GBR and equity in the ratio of 8:3.
I mean, you've elected not to seek an account of profits.
Well, as against
Mr.
Quite.
As against Mr. Monks.
As against Mr. Monks, quite. But not as against...
Not as against
not against GBRK, no. So, I think it's common ground to this extent between my learned friend and myself. When the court is considering an account of profit, the touchstone is proportionality. One gets that from the Gray decision that your lordship was sat on. There needs to be it's not a causal link between the business diversion and the profit, but there must be a reasonable relationship. And what we say is the right answer here is to draw the line in 2015. And so...
why did you choose that date?
The relevance of that, as I will take you when we deal with ground A, which is...
Just tell me now.
Why
choose 2015?
Because that reflected the commercial intentions of the parties. The idea...
This agreement that Mr. Davies said he had with Mr. Monk, that he would last for a few more years.
They would trade for 5 years, achieve a 5 million turnover, and then there'd be an exit at that point. And so... what I say is that if the court chooses that date, that accords with the parties' commercial intentions.
It doesn't accord, though, with the liability judgment, does it?
Well, my lady, in my submission it does. I accept that there wasn't a concluded shareholders agreement, for example, reflecting that. But Mr. Johnson did find that the terms of the handover note, as he described it, were known to Mr. Monks and reflected the discussions and the intentions of the parties at the time. But I accept there wasn't a concluded shareholders agreement which said we'll trade for 5 years and then there'll be an exit. I accept that.
Okay. And also, Mr. Shaw, therefore, you, if you like, take a diversion around the conclusion that GBR couldn't have gone on after October 2011 on the basis, A, of this, the handover note agreement, and B, on the basis that one should recognise what had been put into the pot. In shorthand terms, what you're saying, i.e. the 800. And therefore, you say it doesn't matter that the judge found that actually GBR couldn't have gone on.
Quite.
Because it had made it, the way you get around that, your diversion, is it had made its contribution and he should have taken account of that.
Quite.
Okay.
I was just explaining why we say the 31st December 2015 is the right date, so where the line should be drawn on the account. I say that is proportionate, and it is fair to both sides. It gives Mr. Monks and the other shareholders all of the upside beyond 2015, and it's not a matter for this court, but the parties' experts looked at, for example, the amounts that Mr. Monks and his family have received by way of remuneration and benefits from GBRK, for example, and it was agreed that the amount is substantial. It was in excess of 2.1 million. That was what Mr. Monk's own expert said. And so what we say is that the right approach here is to recognise in the contribution my Lady Justice Asplin has just referred to. I'm not seeking a present-day valuation, but I say the right approach is to draw the line in 2015, and that will give Mr. Monks and the other shareholders all of the upside beyond that point. Again, it's not directly a matter for this court, but just to illustrate that Mr. Holland didn't make findings about the value of GBRK beyond October 2011 because the decision he made he didn't need to. But if I could just illustrate, I included a table in my closing submissions which just sets out the parties' experts' rival valuations, and I'm going to show you that. It's bundle 3, tab 9, page 111. Just the table in the middle of the page. So you see that, the quantum trial was a while ago now. That was April of last year. But Mr. Hall, who was Mr. Davies' expert, estimated that the value of GBRK was 7.3 million, subject to a potential uplift we don't need to worry about today. Mr. Hayward Crouch said 3.7 million odd. The principal distinction between the experts was about the appropriate multiple. But I mean, what one can see that there has been even on Mr. Hayward Crouch's more conservative approach, there has been a substantial increase in value since 2015. And I've been explaining to the court why I say that the outcome is, with my respectful submission, unsupportable. What has happened is that the knowing recipients got away with it. The no order for no account was ordered against the knowing recipient, and so everything that GBRK received. Plant, machinery, skips, lorries, vehicles, customers.
Well, there were no customers according to the liability judgment.
Well,
you see, the one thing that is clear from reading your skeleton is that you do take several pot shots at findings that were in the liability judgment, but there's no appeal from it. So we do proceed, don't we, on the basis of what the liability judge found?
My lady, yes. I mean, I don't accept. It certainly isn't my intention to take pot shots at the liability judgment. I take your ladyship's point. There isn't a. I mean, this is the paragraph 272 issue.
No, it isn't actually. It isn't the 272 issue. I mean, it's reading the judgment as a whole. And having regard to some of your written submissions, you do appear to seek to go behind findings that the liability judge made. But one of the things that I can say most definitely is he found that there were no customers, that this wasn't a continuing customer base, that it was more ad hoc than that.
Sorry, my lady, I'd misunderstood. This is the point about you're only as good as your last skip. I mean, what is clear is that GBRK was trading in 2011, and I can show you the accounts for GBRK.
But that's not your point. What you were saying is that this is somebody, and this is when you're talking about the unsustainability of the judgment. This is someone who comes along and takes somebody's customer and runs with them. But the liability judge found that there were no customers as such.
But lady, I accept that, but my point is this, that it's a sort of pre-existing property point again. In my submission, in order to make good my claim for knowing receipt against GBRK, I don't need to show that there was an existing contract entered into between GBR and a customer, which was then transferred across to GBRK.
Yes, but I just then take you up on the point that you were expounding, that somebody comes along and takes the skips and the lorries and the customers, and I mean,
but even if you buy them,
we're not a jury.
Understood. My point was this, that if you if Mr. Monks was looking for business, there was a website, so by order, you can hire a skip. If that customer entered into a contract with GBRK, that was a breach of duty owed to GBR. It didn't matter that there was no existing contract between that customer and GBR, which was then assigned across to GBRK. The point is, it was a situational conflict. And so when sorry, it's my fault for being too loose in the way I put it, but when I talk about diversion of customers, what I mean is that until October 2011, when GBR was struck off and dissolved, Mr. Monk's duty of loyalty required him to direct new customers to GBR.
As the judge found.
Yes.
Yeah, as the judge found.
So the position is that because, number one, the judge held that for the purposes of Mr. Holland, I should say, when I say the judge, Mr. Holland concluded that Mr. Davies was only entitled to a remedy in respect of the matters listed in paragraph 272 of the liability judgment, and on the basis of the judge's conclusion, legal conclusion, that you need pre-existing trust property to found a claim for knowing receipt. The consequence of those two findings was that GBRK got away with it. And I obviously challenge both of those points. I say that the judge read the liability order too narrowly, and as I've already explained, I say that pre-existing trust property is not a necessary ingredient of knowing receipt.
You can't start from a kind of a priori assumption that somebody who receives a knowing recipient is going to end up being liable. After all, I mean, the knowing recipient is not subject to a fiduciary duty. Liability attaches only if you fulfill the well-known conditions for knowing receipt, one of which, following buyers, is the property has to be subject to a trust at the moment of receipt. And I can't understand at the moment how you get over that hurdle.
Well, I mean, I don't. So I'll take you to.
We'll be coming to this
well,
later.
We'll come to Cook and Deeks and Buller and Buller, but I don't. I certainly don't accept that that buyers in some way overruled Buller and Buller.
No, but Buller and obviously we'll need to look carefully at Buller and Buller, and then there are bribes. But on any view, they're rather a stressful case. And,
yes.
Yeah.
So I mean, that's a sort of in a thumbnail sketch of knowing receipt. As for equitable compensation, what Mr. Holland has found is that it is, in this type of case, it is compensatory. So the equitable compensation is payable to make good a loss. So it's akin to a common law damages claim. And it is for that reason that Mr. Holland limited the relief in respect of equitable compensation to the value of GBRK in October 2011, because he said GBR couldn't have traded on, so any increase in the value of GBRK beyond October 2011 would not have accrued to GBR. I say that is wrong as a matter of principle in this type of case. This isn't. The judge characterised this as a type of case in which a fiduciary fails to obtain trust property. I don't accept that that's the right characterisation. This is akin to the bribe cases. This is a fiduciary who acts in breach of his duty of loyalty and takes for himself property which he ought to acquire for the benefit of the trust, in this case, GBR. And so I say that the equitable compensation ought to have been awarded on a restorative basis. As FHR establishes, the primary obligation of a fiduciary is to get in the trust property, look after it, and distribute it. We're obviously talking here about we're dealing with a company, but directors are treated as akin to trustees. If a director takes a bribe, it's a slightly silly example, but it illustrates the point I'm making. I've used it in my skeleton. Let's say the bribe is an oil painting. If a director receives an oil painting, then we know from FHR that at the point of receipt, it is impressed with a trust. It is trust property. And the director's primary obligation is to hand it back. And so if the director hands over the oil painting to the company, that's the end of the story. That's got nothing to do with loss. I know it is sometimes said that in a bribe case, the amount of the bribe received by the director is equal to the loss sustained by the principal, because it said it is to be assumed that if the supplier was willing to pay a bribe, that the supplier would have charged the principal less. But the Supreme Court made it clear in FHR that wasn't the ratio. This has got nothing. I'll show you FHR, but the Supreme Court made it plain. It's got nothing to do with loss. It's about putting back. It's about putting back trust property. And so what I say here is that this wasn't a compensation case at all. This was a case about restoring trust property. Mr. Monk's primary duty was to restore the business which he diverted, and that was a continuing duty. There is obviously the complication in this case that GBR was struck off the Register of Companies and dissolved on the 18th of October 2011. And you will have seen that Mr. Johnson held that upon the restoration of GBR, GBR is deemed always to have been in existence, but that didn't have the effect of retrospectively restoring Mr. Monks to his office as a director. So, and there was no appeal against that, so I accept that. So from the 18th of October 2011 onwards, Mr. Monks didn't owe duties as a director to GBR. But that doesn't really meet the point I'm making. GBRK held trust property. Everything that GBRK had belonged in equity to GBR. And Mr. Monk's primary duty was to deliver that back to GBR. And that was a continuing duty.
I mean, where is this getting you, given that the equitable compensation, which the judge fixed at £800,000, was intended to restore precisely the total value of GBRK at that date? I mean,
Well, it takes me to the importance of that. It's the next stage, which is about valuation. So you give back the property in specie. If you can't, you have to pay. It's a personal remedy for the value.
yeah.
But I mean, when you assess the value, you do it with hindsight. We know that. And in valuing that, in valuing the trust property which has been diverted, in my submission, you must take into account at the point of trial the fact that it's this was an income generating business, and that's not about tracing. That's a valuation point. And we know from the work the experts have done, we know it was an income generating asset, and it was very successful. It wasn't on the essential reading list, but I will take the court to it. I do rely on this, an old case, I think it's pronounced Nancy, Glow and Blainer. It was, but I mean, the facts of that case are they demonstrate how strict this principle is. In that case, the secret commission, a promoter gave a director shares, which he shouldn't have had, gave him 500 shares. Those shares went up in value to £80 a share, but by the time of the trial, the claimant company sought an account in equity. By the time of the trial, the value of those shares had declined back to £1 a share, and the director was prepared to hand over the shares, but the court said that's not good enough. You've got to pay £80 a share. So what the principal could do was to select the highest intermediate value, and that's on the basis that the shares were trust property, and the trustee should have taken instructions from the principal and turned those shares into money. And so what I take from that is that when the court is assessing equitable compensation on this basis, on a restorative basis, you're not fixed with the value at the date of diversion. The court applies hindsight. This isn't a case where the value went up and has gone down again. We know that. The value in 2015 is lower than it is today. But I am entitled to compensation at the highest intermediate point. And the Nancy Glow case is approved by the Supreme Court in FHR.
I have to say, for my part, Mr. Shaw, I think I would be helped now if we could move to the specific, because I'm getting a little lost in the morass of the general.
Yes, of course. Let me move to ground A, which is essentially a construction point. As I explained earlier, the judge concluded that Mr. Davies' entitlement to relief was limited to the 7 matters set out in paragraph 272 of the liability judgment.
Will you just wait till I get your grounds of appeal so I can cross-refer them? Thank you. So it's behind tab 4, yeah?
Yes. Round A.
Thank you very much.
This is a question of construction, but it's important to identify precisely what is to be construed. The relevant document to be construed is the liability order. If we could go to that, that's bundle 2, tab 29, 126.
Before we do, in the respondent skeleton argument to your appeal, there's reference to dialogue that took place at the time of that hearing. And I just wondered if you accepted that as accurately reported.
I don't. I was going to. I was going to take the court to that. I could. Could I take you to the liability order first, and then?
Of course, but don't forget that we've got that we've got to resolve. So reference.
Sorry, I think I might have the wrong reference. I was tabbed. I said tabbed. Bundle 2, tab 29.
29, I think.
Yeah.
The relevant paragraphs 2 and 3. The point I make about this is that the relief is expressed in general terms. It isn't restricted to paragraph 272. I anticipate it might be said against me, well, if Mr. Davies had wanted broader relief, it should have been spelt out in the liability order. But my response to that would be, I won the argument about the scope of the liability order. It is in general terms. So that's a segue into Lady Macur's point. I'll take you to the transcript. But I did have a debate with my learned friend about paragraph 2 of the order. My learned friend sought to persuade Mr. Johnson to limit the scope of Mr. Davies' entitlement to relief to paragraph 272. I resisted that, and Mr. Johnson agreed with me. if I could ask you to take up bundle 3. It's tab 21.
I'm sorry, 321.
Yes, page 271. If I could just ask you to read from Mr. Shaw, this was Mr. Johnson asking me a question. Mr. Shaw, any objection to adding in the language at 1412? That was Mr. Cook's suggestion that the liability order should refer expressly to paragraph 272. If I could just ask you to read that down to E, and then I'll make some brief submissions about it. So I made it clear that I objected to a reference. I objected to an order that GBRK's liability for knowing receipt be limited to pre-existing property of the company. The court may understand the relevance of the 22nd of May 2011 date, but just let me explain. There is a limitation point which is relevant to GBRK, but is not relevant to Mr. Monk's. GBRK is an accessory; it's not a fiduciary. So the claim was issued on the 22nd of May 2017. So the claim against GBRK is subject to a 6-year time bar. That doesn't apply to Mr. Monk's because Mr. Johnson held that he was dishonest, and therefore section 21(1)(a) of the Limitation Act applies. So what I was saying is I certainly objected to any reference to pre-existing trust property, but I didn't object to the inclusion of the 22nd of May 2011 date. So what I was saying is I accept that the claim against GBRK is only in respect of receipts on or after that date. That's why I said I have no great objection to that. And then the deputy judge said that yes, it's clear enough actually. I don't think we need to modify the language. But the key point is that was direct in my submission on an ordinary reading. That was directed at the point about the date. That's what the judge was saying. It's clear enough that the claim against GBRK is in respect of matters on or after the 22nd of May.
I'm not sure I agree about that. It seems to me the judge is making a more general point. He's saying, I've said what I've said in the judgment. The order must obviously be read in the light of the judgment. And I don't think it needs to be spelled out any more clearly, in which case, seems to me, I mean, that just takes you back to 272 read in context. But doesn't necessarily accept, well,
my lord, I mean, you've heard my primary submission, yes. But even if it was a general comment, what I would say is this. You have an order in general terms. It's obviously got to be read in light of the judgment. But the real question, the real question for this court is there anything in the liability judgment which would justify cutting down the scope of the liability order? I mean, the liability order is in general terms. It doesn't refer to paragraph 272 at all. So if you go, looking at the liability judgment in that context, is there anything in it which indicates that Mr. Johnson intended to restrict Mr. Davies' entitlement to the matters in paragraph 272 alone? And I will refer you to the key parts of the liability judgment I rely on, but I would just say this before we sort of dig into it. I mean, on a fair reading of the liability judgment, it would be, in my submission, most surprising if Mr. Johnson, for example, had intended to exclude liability for new customer contracts taken by GBRK. There's no reference in paragraph 272 to GBRK fulfilling new customer contracts. And that the fact that Mr. Monks pushed potential customers to GBRK rather than GBR was an obvious breach of duty. Mr. Johnson didn't refer to those customer contracts, the GBRK customer contracts at all. But what my learned friend must be saying is that implicitly, Mr. Johnson has excluded the possibility of a remedy in respect of those customer contracts. But, I mean, on a fair reading of the liability judgment, what Mr. Johnson has found is that this was a fraud. This was a fraudulent scheme. If I could ask you to take up the liability judgment, it's tab 16 of bundle 1. If I could ask you to refer, first of all, just to paragraph 6, where Mr. Johnson sets out in broad terms the defence which was advanced. Mr. Johnson was faced essentially with two competing views of the world. Mr. Davies said that this was a fraud. So what Mr. Monks did was he was appointed as managing director of GBR. He saw there was a valuable business opportunity there, so just 2 months later he incorporated GBRK and began to trade through that company instead. Mr. Monk's story was very different. What Mr. Monk said essentially is that he acted honestly and in response to a bad situation created for him by Mr. Davies. And so he says, as Mr. Johnson has summarised here, what Mr. Monk said is GBR was insolvent, there were all sorts of problems with the site, and I reacted in a lawful and proper way. I was simply trying to, in essence, he was saying that he conducted an informal liquidation of GBR. That's in essence what he said.
Mr. Shaw, how is all this helping us? I think we're going back to the general rather than the specific. What we're looking at is ground A, and how to construe the order in the light of the judgment and paragraph 272. And it seems to me we've gone back into an enormous landscape where you're taking us back to the fact that there's, according to your client according to your client, there's been a great deal of dirty dealing. And in doing so, it seems to me you're also seeking to creep behind the liability judgment. We have the judgment, and it is a mammoth work, and that is enough for us, and we need to concentrate on what it says. So could you take us, therefore, to what's relevant specifically to how we construe paragraph 272 in the light of the order?
My lady, I apologise. The reason I wasn't seeking to descend into the general. The reason for making the point about paragraph 6 was this. It goes back to the previous point I made. On a fair reading of the judge, my basic submission is this: what the judge has found is this was a dishonest scheme. The judge wasn't saying, I find these 7 matters in paragraph 7 dishonest, and I exclude everything else. I'm saying that was the point I was seeking to make. But I will move forward. If I could ask you to turn to page 192, which is 191. It's the start of Mr. Johnson's discussion of the consideration of whether there was a breach of duty. And it's paragraph 260. The judge records, essentially my case was, it was a breach of section 272, the duty to promote the success of the company, and section 175, duty, the duty to avoid conflicts. And then at paragraph 262, the judge deals with an assessment of the position of GBR. 263, the judge found the position is a messy one. And then at 264 and 265, the judge considered Mr. Monk's case that GBR was insolvent. He rejected that. At 267, the judge comments that there's been a misplaced emphasis in determining whether Mr. Monk's in breach of duty on the question of what existing corporate assets of GBR had and whether they've been misapplied. We've then got 269 and 270, the judge's consideration of Buller and Buller. I'll take you to that. And then 271, in light of these comments, in my judgment, the proper approach to assessing whether Mr. Monk's is in breach of duty and leaving aside the question of limitation involves one asking not only whether pre-existing corporate assets of GBR were misapplied, but also more pertinently whether his actions were wrongful. And then this is the paragraph that my learned friend relies on. As will be readily apparent from the narrative above, the factual background is somewhat confused, and despite my best efforts to decode the evidence, a number of gaps and omissions remain. Notwithstanding that, a number of points are clear, and in terms of what Mr. Monk did, they include the following. And so, what I say about this is clear from those opening words. What Mr. Monk did included the following points. This wasn't expressed to be an exhaustive list of what Mr. Monk did wrong. All that Mr. Johnson was doing was deciding whether there was sufficient evidence to sustain a conclusion that Mr. Monk had acted in breach of duty. And so, if one goes on to 274, the judge start with section 175. Seems to me that each of the steps identified above involved a breach of Mr. Monk's of his duty under section 175. Sorry, I've missed out 273. You see, each of these steps on the face of it involve Mr. Monk's in breach of duty. And then if you go on to page 207 of the bundle, under the heading limitation, the judge started with looking back at 272 above. Item 3 listed in paragraph 272 is the use of GBR's funds to clear the Ashford site. Paragraph 326, as regards other breaches of duty in 272, they will be time barred unless fraudulent.
Well, that seems to be against you in terms of it being the judge's specific reference in all of these paragraphs that you're now taking us to those 7 items in paragraph 272.
Milady, yes, but my response to that is that all that the judge was doing was deciding whether Mr. Monks had acted in breach of duty, and what he's addressing here is whether or not Mr. Monks was dishonest.
But 326, paragraph 326 that you've taken us to, it follows, as regards the other breaches of duty identified in 272 above, that they will be time barred unless fraudulent. But he doesn't identify them, does he?
I'm sorry, I'm not sure I follow your ladyship.
Well, I'm reading 326, as you've asked us to. The other breaches of duty identified. It's specific. He's talking about limitation.
What?
As regards other breaches identified above, they will be time barred unless fraudulent.
My lady, yes, but what I'm saying is this: what the judge has done is to say, first of all, what happened. The picture was a mess. He said the picture is messy, but in terms of what Mr. Monks did, it included the following things. And then say, were those breaches of duty? Yes. There was then a question. There was then a limitation question.
Yeah.
And I would only get out of the 6-year time bar if I could show either it was pre-existing trust property or it was fraud.
Yeah.
And then the judgment was, yes, it's fraud. So what I'd say about this is it's not. It wouldn't be credible to suggest, for example, that Mr. Monks was dishonest in taking the steps set out in 272, but honest in relation to everything else.
No, I understand that. But what you're trying to do is to say that this is a non-exhaustive list in 272.
Yes.
But, for example, in 273, in my judgment, and leaving aside for the moment any modification of the orthodox position which might be said to arise from GRBR being insolvent or of doubtful solvency, each of these steps, referring to 272, 274, each of the steps identified above, referring to 272, and every other paragraph that you took us to, ending with 326, goes back to 272, which does seem to suggest that the judge, the liability judge, did regard it as an exhaustive list for the purpose of what he was able to find. And therefore, for the quantum judge to be able to say, well, I think it is an exhaustive list, you say was wrong, and that's what you need to get round in your ground A.
I accept that's my task, but my what I say about that is that all the judges. I don't want to. I heard Lady Justice Asplin's comments about my submissions on paragraph 6. I don't want to go back to it, but what the judge was trying to decide was whether or not Mr. Monks had whether these were honest actions or not.
We understand that.
And so
we understand that.
All the judge needed to. But what I'm really saying is, all the judge needed to do to reject Mr. Monks' defence was focus on those 7 issues, 7 factual matters in paragraph.
But he would only have needed to focus on one of them if he needed to do that. I mean, you look at that particular paragraph, 272, not in isolation of the difficulty that he indicated at other stages of the judgment in having 2 prime witnesses whom he did not feel able to rely upon without reference to corroborative materials. This isn't all one way, and therefore he does make clear, as will be readily apparent from the narrative above, that is, those particular paragraphs that go from paragraph 260 and 261, which give the respective cases, the factual background is somewhat confused. And despite my best efforts to decode the evidence, a number of gaps and omissions remain. So he's obliged to make findings where he can. And these are the findings he believes he's able to make, and nobody has taken issue with that by making an appeal against this finding. Certainly not before the quantum decision came out, anyway.
But lady, yes, although I fall back on the point I made before about the terms of the liability order. I mean, to take up your ladyship's point, I sort of asked rhetorically what I would have been appealing against, because I got an order for knowing receipt and equitable compensation in general terms. Of course, I recognise that if Mr. Johnson had directed, if he had made an order that Mr. Davies the judgment be entered into against Mr. Monks and GBRK only in respect of those matters in paragraph 272, I obviously I would then have a problem, and the only way I could have dealt with that is by way of an appeal.
Okay, so I think that's a fair point, Mr. Shaw, but then comes an issue, doesn't there, as to whether or not it would have been appropriate and proper for either you or you would probably say Mr. Cook's side to seek clarification. Because your point is that at the liability order stage, Mr. Cook tried to get the judge to limit to that respect 272, and the judge says, well, just read the order. Sorry, forgive me, read the judgment.
Yes.
So it now comes down to, not that you say he definitely meant this, but that there's a different interpretation placed by each side upon it.
I do. And I mean, one obviously must read the liability judgment as a whole. I haven't got time, and you don't want me to take you through every paragraph. But I would ask, I would respectfully submit what the court should do is just take a step back. So looking at the whole of the findings, was it I asked, really Mr. Johnson's intention to limit Mr. Davies' right to relief just to those 7 matters when, as part of GBRK's trading, well, we know it was trading, it was doing other things. It received property, it received cars, skips, and so on.
Well, as you say, we've got to read the judgment as a whole. That's the point, isn't it?
It is. May I just refer? Sorry, I was just going to. You've picked me up on the passages where the judge said, referring to paragraph 272. Can I just show you 2 more?
Yes, please.
It's paragraph 338 of the judgment. I just ask you to read all of it, so I'm not accused of quoting selectively here. I accept that the first paragraph contains the first sentence contains the words "in taking the steps identified in 272 above," but I do rely in particular on the second sentence.
I say that essentially. That's the one you're referring to,
Yes.
And presumably you're saying, therefore, this is all about honesty, dishonesty, and that's his focus.
Yes.
So I'd like to step back and ask you, therefore, what the liability trial was about and what you thought that Mr. Johnson was doing. Was he just going, oh, what's gone on here? Let me put it down on a piece of paper and let me see whether it was time barred or fraudulent. And that's all he was doing? Or was he, when determining liability, determining what breaches there had been? What was the compass in your estimation of the liability judgment?
May I respectfully just park that for once? Can I just take you to one? This may very well answer your ladyship's question. Could I just ask you to go to 395? This is relevant because what the judge is dealing with here is he's referring to the matters that will be addressed at the quantum stage. Just to put this in context, there was no appeal against this, you'll be pleased to hear. But what my argument was essentially that what I said is that when GBR was restored, the statutory consequence of restoration was that Mr. Monks was deemed always to have been a director. So I said, at the time, even the business that GBRK was conducting at the time of the liability trial, each of the new contracts were held on trust for GBR. So I said there's no tracing problem here because Mr. Monks is still a director. Mr. Johnson rejected that, so that's the context in which he made these comments. So at 395, what the judge does is he rejects my argument that GBRK's then current business was held on trust for GBR. And he then went to say issues therefore remain will have to be addressed at the further trial concerning the form of relief to be awarded and its extent. That gives rise to difficult issues as the scope of a fiduciary's liability to account, case where the opportunity has been diverted and new business built up with the benefit of an errant fiduciary's efforts and capital investment. So the point is that the judge was very cautious about going no further than he needed to go for the purposes of finding breach of duty and dishonesty.
Yes, he also says further up, I do not consider that the question of what remedy follows from the breaches of duty I have identified. So he does think he has identified the breaches of duty.
He does.
The consequences of that and how that flows out is to be determined later,
Yeah.
but he has found the breaches.
I sort of, to draw the strings together, I make two submissions. I mean, the first one is I don't accept that I needed to ask Mr. Holland to make further findings of breach of duty. So I don't accept that as a proposition. The court, having found that Mr. Monks breached his duties in the ways in respect to the matters set out in paragraph 272, the next stage was taking an account and working out how much is to be paid. And you've
By the company or by the
both.
fiduciary? Because how did you plead this?
I can show you. It was pleaded as a claim for. Sorry to start again. There were two sets of pleadings. There were pleadings at the liability stage, and then there were pleadings at the quantum stage. At the quantum stage, I sought equitable compensation as against Mr. Monks, and a declaration of constructive trusteeship in respect of the site against GBRK, and an account of profit.
And in your pleadings at the quantum stage, I mean, did you expressly raise this point about paragraph 272?
Certainly. I mean, I can show you that.
And I would like at some point to see how you put it in your
It's
formal.
tab bundle 2, tab 26.
Thank you.
This is my reply. If I could, if you pick it up at page 93. It really starts, I suppose, at paragraph 2.6. If you skim that and then get through to 95 and paragraphs 2.8 and 2.9.
So your 2.62 is exactly the argument that you've just made to us about it being non-exhaustive. Mr. Johnson did not purport to identify whether in 272 or elsewhere, or business opportunities, property asset, etc. So this is about the diversion of business.
Yes.
Moreover, it cannot be sensibly contended that merely because Mr. Johnson did not make a specific finding of dishonesty in relation to the diversion of customer contracts, Mr. Ford and Mr. Monks are to be treated as having acted honestly. Well, that's not quite the point, is it?
Well, that but my lady, no. I don't believe that point is advanced in this court. But certainly below, my learned friend said that because Mr. Johnson didn't make any express findings of dishonesty about diverted contracts, the court should proceed on the basis that Mr. Monks was honest.
Well, that was against express findings within the judgment, wasn't it?
Quite.
Yes.
Yes. And then, if the court goes to paragraph 2.8 on page 95,
Sorry.
I've set out the relevant paragraph of the liability order. And then 2.9 is by way of fallback, and it's by way of fallback in this court. I mean, if it is necessary for me if contrary to my primary submission, this court takes the view that it was necessary for Mr. Holland to make further findings of breaches of duty in order for me to obtain relief, not just in respect of the paragraph 272 matters, I say there's no reason why Mr. Johnson could not have made those findings. There's no abuse. There would have been no abuse. It isn't as if Mr. Johnson made an express finding, for example, that there were no other breaches of duty. I mean, I accept if Mr. Johnson had said, I reject Mr. Shaw's case that Mr. Monk's acted in breach of duty by directing customers to GBRK, the only way I could have dealt with that is by way of an appeal.
Well, what the quantum judge did, we find in paragraph 32 of the judgment. And then, and he's referring specifically to this issue, isn't he? Because he says, the judge then deals at paragraphs 267 to 279 with the allegation that Mr. Monks was in breach of his duties as director. As the meaning of certain of these passages, and in particular paragraph 272, is an issue before me, I feel constrained to quote the relevant paragraphs at length, and he does so. He then, having supplied emphasis, the words underlined in the quotation from paragraphs 271, 272 were emphasised by the judge in the judgment. I have added the emphasis in bold to those and to certain other words as the meaning and effect of the words in paragraph 272 is in dispute before me. To my mind, the word they in the phrase, they include the following, more naturally refers back to the words, a number of points are clear, and not the words in terms of what Mr. Monks did. The judge then dealt in paragraphs 276 to 279 with the point made by Mr. Monks that GBR was not itself in a position to exploit. Judge dealt with that point, and then it's the judge's take on this. Why was he wrong? Just because well, you say because it's different from what I'm submitting, but
well, I mean, I respect. I mean, this is a construction point.
And you're entitled to say it's a question of construction, a question of law, therefore, and one we can form our own view on.
Indeed, I mean, I respectfully submit that Mr. Holland has construed the liability judgment in too narrow a way. I mean, that's the
right. That's the point.
That's the basic point.
Yeah. So, so have I correctly identified those parts of the judgment that we've got to scrutinise, the quantum judgment that we've got to scrutinise, when we're looking to see if he was unreasonable in his construction?
Yes. I mean, my learned friend took Mr. Holland to the paragraphs that I've taken this court to, and Mr. Holland was no doubt impressed with the references to look at paragraph 272 above.
But haven't we got to look at what the judge did in his construction rather than to do it de novo? We look at what he arrived at and say, well, was that a reasonable construction for him to reach, bearing in mind the arguments that Mr. Shaw makes and the arguments that Mr. Cook makes? And then move on elsewhere.
Yes, I mean, well, of course, if you wish me to, I will do so. I wasn't proposing to take you through the way the judge approached each of those paragraphs. But if one skims it from paragraph 30,
I'm just interested to know whether we've got the right part of the judgment that we should be focusing on for your ground A.
Absolutely, and it starts really at 34, goes through to 54.
Right, thank you.
And then and then it's paragraph 75 to 91. Yes, yeah, page 263,
Thank
the
you.
heading construction of
Yeah.
the judgment.
Just so I'm clear, however, I'd just be grateful for your picture of the division of labour between Mr. Johnson and Mr. Holland. You get a liability decision from Mr. Johnson. I'd just like to know what, as a thumbnail, you consider he was doing. And then he passes the parcel, the hot potato, on to Mr. Holland, and what it was that you considered was the scope of everything that Mr. Holland could do.
Yes, certainly. The what Mr. Johnson did was all that he needed to do to determine that Mr. Monks had acted in dishonest breach of duty and therefore was susceptible, to put it in sort of traditional trust terms, was susceptible to an account. So an account could be taken
A range of equitable remedies.
and that was it. And I mean, it's clear from Mr. Johnson, from the way Mr. Johnson expressed himself towards the end of the judgment, when he dealt with, I've showed you that paragraph when he referred to the quantum being a matter for later on. It's the same when you look at the comments he made about equitable allowance. He was very cautious, and he was really leaving a lot to the quantum stage. So I've rejected the case that this was an honest response to a bad situation. I find that Mr. Monks acted dishonestly. He dealt with the question of a limitation. He rejected my argument, unfortunately from my point of view, that all of GBRK's business was held on constructive trust. And he said, right, to work out the nature, the extent of the remedy, that's for the next time round.
And then, what was the scope that was, according to you, left for Mr. Holland?
Well, it was to identify. We probably should go back to the liability order. I think paragraph 3.
No, I think we've got that in our heads. But how wide, therefore, do you say was the ambit for Mr. Holland?
Mr. Holland was looking at everything diverted, all the business diverted to GBRK up until the 18th of October 2011. And that was step 1. Step 2 was to say, well, and what relief flows from that. So, and that was a question in my submission. That was about choosing the right date, essentially. So, the question: was it appropriate to order an account of profit, and if so, up until what point? As I explained at the beginning, in fact, the judge drew the line in October 2011. But in order to answer your ladyship's question, I certainly don't accept that at the quantum stage the judge was confined to looking at those 7 matters. That provided the basis for the taking of an account, and that's the point. That's the Chancery Master with his quill pen. So right, the trustees act. The trustees in default. Right, let's find where the trust property is, and work out what remedy is available flowing from that.
Thank you.
Is it material? I suspect it isn't on analysis. That, of course, Mr. Johnson was assuming, as everybody would have done, that the quantum trial was going to be conducted by him. Indeed, it's the direction to that effect, if he's available. And I suppose it was his appointment to the bench, which meant he wasn't able to do it.
I don't know I don't know what the background to that is, but he yes, certainly there was a direction to the effect it should be before the same judge, if practicable.
Yeah.
And my recollection is it was probably maybe a month beforehand. He indicated he wouldn't be available, but my lord is right.
Anyway,
that
for whatever reason,
that was certainly the assumption.
That was the assumption.
It was certainly the assumption.
More than an assumption, it was a direction.
Yes. Yes. I mean, unless I can assist the court any further with ground A, I mean, it's a construction point, and my submission is that Mr. Holland has construed the liability order against the background of the liability judgment, and he's construed the liability judgment in too narrow a way. Ground B is a question of law. This is the question of whether to found a claim in knowing receipt, you need pre-existing trust property. Mr. Holland found that you do. The consequence of that was that everything, all of the new property which GBRK obtained in what I've called the second period, and by that I mean between the 22nd of May 2011 and the 18th of October 2011, couldn't found a claim for knowing receipt. So the vehicles purchased, the new skips, the new customer contracts which were entered into and fulfilled by GBRK, none of those could found a claim in knowing receipt. And I say that that is incorrect. To pick up my Lord's point about buyers, just to repeat, of course I accept, it's a decision of this court, there has to be receipt, but where I do quibble is with the notion that there has to be pre-existing property transferred from GBR to GBRK. And I rely principally on, well, there's two lines of authority. It's the FHR case and also Buller and Buller. If we could start off with FHR, you'll appreciate that the leading cases, they're relevant to knowing receipt, they're also relevant to equitable compensation, so I'll try and avoid, I'll try and make the points I need to make in relation to both of those issues, so we don't need to go back. The FHR decision is in the Authorities Bundle 3, tab 47. I'll take you through the decision of this court in FHR and then the Supreme Court. Both my learned friend and we rely on, I think, the decisions in both levels. The court will understand this was a case about bribery. It was involved the purchase of a hotel. The buyer's agent received a secret commission, a secret undisclosed commission from the hotel owner, and it was a claim to recoup the amount of the bribe. The issue, the question for the court was whether or not the bribe was held on constructive trust. So the question was whether there was a proprietary remedy available to the principal in respect of the bribe. Again, I'm sure this is familiar territory to you, but the problem, the difficulty facing this court was that the decision in Lister and Stubbs indicated that a bribe was not held on, there was no proprietary remedy available. The Court of Appeal was able to distinguish Lister and Stubbs and Sinclair and Versailles, and held that the bribe in this case was held on constructive trust. The Supreme Court obviously wasn't bound by Sinclair and Versailles, so concluded that to that extent it overruled Sinclair and Versailles and said that a bribe is held on constructive trust. I take you to this first. This is obviously this is not looking at knowing receipt. This is a claim against the fiduciary himself. But if one asks, do you need, in order to found a claim, in a constructive trust claim against the fiduciary, or a claim for an account, does the fiduciary need to receive existing trust property? The clear answer to that is no.
But what does that help us at all in relation to a third party? Because the trustee himself, the director himself, is a completely different kettle of fish. That may be so, and one can quite see why it should be so in relation to a trustee. But we have to think about what the situation is in relation to the knowing recipient.
I understand that. I wanted to start. Sorry, I didn't mean to be disrespectful.
No,
I understand the point your ladyship makes.
No,
I mean,
quite the reverse. I also thought. Of course you do.
I wanted to sort of to put in place the building blocks to look at the position of the fiduciary first. But what I'm going to submit is it's clear from FHR that if a fiduciary acts in breach of his duty of loyalty, the property which he receives is impressed with the trust from the moment of receipt. And there can't be any doubt about that now. And the point I'm making is this: the case my learned friend advances is this. He would accept, I think, that if the trustee receives the property and then hands it over to the knowing recipient, there's a claim. But there's no claim if the same bribe goes straight to the knowing recipient. So take my oil painting example. This is the art-loving dishonest director. The dishonest director is given an oil painting by way of a bribe. He holds that on trust from the moment of receipt. Nothing to do with suffering loss. That's trust property. He's got to put it back. If the director then takes that oil painting and hands it to his company is liable because you have pre-existing trust property, and assuming, of course, that one establishes knowledge, then the knowing recipient is liable as an accessory. However, it must be that on my learned friend's case, it must make all the difference as to exactly how the bribe is paid, because if the oil painting goes straight to the knowing recipient, there's no claim. And I submit that is extremely unattractive, but it also sort of it gives goes back to my point about the roadmap for dishonest directors. It's very clear what you do. If you want to divert business, don't take it yourself. Send it to a knowing recipient. Send it to a company, because that company is not going to be.
There's always a third party involved in your examples, Mr. Shaw.
No, my lady, it wouldn't make any difference.
Well, what you're saying, if you want to divert business, don't take it yourself. Take it to your company. So there's a third person assisting in that diversion. In the oil painting example that you've put forward, if Party A wants to bribe Party B to accept its terms over somebody else, and delivers direct to Party B an oil painting, then that certainly is, in certain circumstances, a knowing receipt of a bribe. So in those circumstances, who's going to be knocking on the door, as Mr. Davies is for us?
Sorry, I'm not sure I've quite understood you. Is Party B? Party
B is the company who takes the oil painting, knowing that it is a bribe.
Well, in that case, there's no claim
Yes. So in this case, that you're taking us, you're building the blocks. FHR, European Ventures. You say the bribe creates a trust.
Yes.
The oil painting in your example.
Yes.
It's trust property.
From the point of receipt.
If that's then put over to Company B.
Company B would be liable in that example because it passed through the hands of the director first.
I understand that. But that's why I'm saying, so when you say, so if you want to avoid all of this, just send it straight to the company.
Yes.
That means that there's no third party involved, as you were suggesting, Mr. Monks was, deliberately avoiding the liability of the trust.
Well, the point I'm making is this, that on the judge's conclusion of law on this point, the company B in your example doesn't receive pre-existing trust property, so it is not liable as a knowing recipient. There's no claim against the knowing recipient.
Yeah.
The director didn't receive the property either. So is there a claim for breach? Did the director act in breach of duty? Yes, he clearly did. So I anticipate what my learned friend will say is there's no lacuna in the law because there'll be a good claim against the director. But I don't accept that because, first of all, an account of profit against the director it requires the director to account for the profits which he himself has made. We know following Petrodel, corporate personality matters, the court will not, unless the circumstances are extreme, the court will not treat the property received by the recipient as property received by the director personally. Now, it might be said, I mean, of course, there might be cases in which the director has an equity interest in company B. And so you might say, well, the director's liability to account for profit is to account for the increase in the capital value of the shares, which is reflective of company B's receipt.
And there's another possibility, isn't there, which is company B just receives as an agent or nominee for the dishonest director. I mean, isn't that the answer to your oil painting case? And if I arrange to have a bribe and try and distance it at one remove, say, don't pay it to me, please pay it to the company of which I'm the sole controlling shareholder and director, I mean, surely that's open to the kind of analysis which Prest recognises, if I remember rightly, or indeed the basis on what the case is actually decided, of the recipient just being basically a nominee or agent for the.
Yeah, I was counsel for the company, so
Sorry,
I remember it well.
You have it very well in your mind.
But my lord, that is one possible answer, but it won't. I mean, that won't always be the case.
No, of course it won't.
I mean, my example of the oil painting is silly, but it's just to demonstrate. You know, it is a piece of tangible property. But I mean, if you let's say the dishonest director diverts this, says, don't give me the bribe, give it to my husband's company, for example. Now, I mean, you wouldn't necessarily assume it's received as agent. I mean, there might be lots of.
Of course, there's all sorts of factual situations, and they're all going to be different. But one comes back to the basic point, doesn't one, that a knowing recipient is not itself a fiduciary, and therefore one does have to find a separate legal basis upon which to impose a proprietary remedy. So it's not to me self-evident that if your answer is no, you can't do it just because the facts haven't fallen out the right way, it doesn't seem to me something that's obviously wrong. Well, I think it all depends on the facts of the given case.
I mean, the court has my point. I mean, in my submission, this is pretty undesirable because this is not an uncommon case. Diversion of business cases are not uncommon. My silly oil painting example is uncommon, but diversion of business is not. Diversion of business cases are all about new property. It's pretty unusual, in fact, that you have an existing contract which is assigned across.
Absolutely, but that's the whole point, isn't it? I mean, you don't have an identifiable piece of property subject to a trust which is being received by a third party. You have new opportunities, new pieces of property, which.
Well, let me take you through FH. I want to show you Buller.
Sorry, yes,
I want to show you Buller and Buller. But I mean, that I would put forward as the answer to my lord's point.
Buller is your ball point.
That's my my two favourite cases are FHR and Buller in this appeal.
Yes. Thank you.
I said I wanted just to take you through the Court of Appeal decision. The lead judgment was given by Lord Justice Lewison. If I could ask you to pick it up at paragraph 41. Well, what Lord Justice Lewison here was talking about cases in which a fiduciary has been disloyal and receives property which ought to be received for the principal, and his analysis is that in those cases the property is impressed with the trust from the moment of receipt. As paragraph 40. This group of cases show the principal can acquire a proprietary interest in an asset acquired by his agent, even though the principal had no pre-existing proprietary interest in the asset. And then over the page at 43, Cook and Deeks, I do rely on that decision. If there's time, I'll take you to it. But that this is probably the most famous business diversion case. That was the diversion of a railway construction contract from the Toronto Construction Company. The directors decided to take the contract for themselves. They formed a new company, Dominion Construction Company. You see here at Paris, what is interesting about this is that the official report, it's a very old case, is ambiguous as to whether it's a pre-existing property case or not, because on one reading of it, the directors took the contract themselves, and they then novated it across to their company Dominion. On another reading, they incorporated Dominion, and it entered into the contract. And it's by no means clear from reading the official report which one it is. What Mr. Holland interpreted that case as a pre-existing property case. So he said the important thing.
But wasn't he right to, given paragraph 45?
Well, my lady, I agree. I mean, what I was going to say, I was going to pick up paragraph 43. I mean, certainly Lord Justice Lewison does not appear to have interpreted Cook and Deeks like that. He said, Lord Justice Lewison said the Dominion Construction Company, Deeks then formed a new company, DCC, for the purpose of entering into the new contract. So,
yes, but in paragraph 45 he says, again, this is not a case in which the principal had a pre-existing interest in the chosen action, i.e. the new contract, which came into existence as a consequence of the breach of duty. Nor did the Privy Council say that the opportunity itself belonged to the company. What belonged to the company in equity was the contract. On the other hand, the Privy Council did not make any declaration of trust, but ordered the taking of an account. On the face of it, this would appear to be a personal remedy, but the account was ordered not only against Deeks and his co-directors, but also against the Dominion Construction Company. Since the Dominion Construction Company was not itself a fiduciary, the order against it could only be justified on the basis that it was in knowing receipt of trust property.
yes, so what Lord Justice Lewison is saying is that, I mean, he's rejecting it's a sort of, it's equitable shorthand. It said an opportunity is treated like property for the purposes of a knowing receipt claim. Lord Justice Lewison is rejecting that. But, I mean, what is interesting about this, and why I rely on Cook and Deeks, Lord Justice Lewison certainly doesn't seem to have been troubled or even interested in the precise sequence of events. He doesn't seem to have been interested in whether the contract was first taken by the directors and then transferred across to Dominion.
Well, but what he is interested in is that there is a difference to be drawn and a distinction. He does not seek to say that you can put the principal as a fiduciary. The only basis upon which the order could have been justified was on the basis that it was in knowing receipt of trust property.
Yes.
Isn't that what he's saying?
Yes, he is, and I mean, I rely on that. I mean, that case in my submission is very helpful to me. I mean, because that is the Privy Council saying there you have new property, namely a construction contract, and the Dominion Construction Company was ordered to account for profit. The only basis upon which it could have done was as knowing receipt.
Was a knowing receipt.
I'm not quite sure if how far that helps you. I mean, what Lord Justice Lewison may have been doing is simply saying, just precisely because there was an obligation to account on the basis of knowing receipt, ergo it must follow that there was a proprietary interest in the contract, without it being absolute, without anyone having made clear how that arose. I mean, he's not necessarily saying it's it would otherwise be obvious from the facts recited. Is it? I don't know.
Well, I mean, I just
from one point,
I was only to show you, but I mean, you have my point. What is certainly from paragraph, if you read 43 to 45, it looks to me as if Lord Justice Lewison interpreted the admittedly rather opaque report. He treated this as a new property case. This wasn't directors take contract, step one, step two, they put it into Dominion. Dominion was formed and it entered into the new contract.
Well, that's not quite right, Mr. Shaw, is it? I mean, if one looks at 43, the company, the original company, had been the successful tenderer in relation to the projects. And so that may or may not have changed the mix, we don't know. But it's in that regard, and I'm not, going back into Cook and Deeks, but that Lord Justice Lewison records that at 43, and then comes to his conclusion about what must have been the case at 45. And it seems that he's concluding there must have been a proprietary interest, or they wouldn't have come to the conclusion that they did. That's all it seems to me that he's saying. And we don't.
Well, my lady, yes, I mean, I accept that, but.
Yeah. And it's in the context, as you say, of a situation in which the original company was a successful tenderer, but didn't have the contract itself.
Correct.
At that point.
Correct. Yes. Entered
into by second company.
Correct.
Yes.
And if I could just ask you to move to, we can jump over paragraph 46. Although there's nothing embarrassing in it, that's not the reason. If I could ask you to read paragraph 47, so my favourite case, Buller and Buller. This was unambiguously a new property case.
But it's the directors who do this, so they are people under duties from the start.
Yes, they
put in a bid for it, which was accepted, and then it was transferred to the newly incorporated company.
Well, again, I'll show you, but in my submission, no. I mean, if one looks at the Court of Appeal decision,
okay.
It was the company which did it. Silvercrest bought the property. It may be that the two individuals.
It doesn't say that. Lord Justice Lewison didn't think that, because the second sentence, forgive me, the third, two of the directors of the company discovered that the next door property was on the market. They put in a bid for it, which was accepted, and the property was transferred to a newly incorporated company called Silvercrest. So it wasn't the new company that was putting in a bid for it, it was the directors who then transferred it to the newly incorporated company.
Well, I mean, I respond to that. I'd make 2 points in response to that. I mean, first of all, when we look at it, in my submission, the fair reading is that they were making a bid on behalf of Newco. But even if I'm wrong about that...
Well, I'm just telling you what Lord Justice Lewison said, rather than what you think he was saying. And he goes on then to quote Jonathan Parker, LJ, paragraphs 27 and 28, who directly returns to fiduciary duty, personal interest, presupposes an existing fiduciary duty.
But I mean, if you see what Lord Justice Jonathan Parker said, I mean, this is I'll take it to the case, but this is the important bit of it. I mean, what Lord Justice Jonathan Parker absolutely rejected is the idea that you have to have pre-existing property. I mean, that was his whole point.
Yes, but that's because he's not dealing with a knowing receipt case. He's dealing with a fiduciary who arranges for the property to put into the name of a conveniently handy creature. But
the order was made. The Silvercrest. A declaration was made that Silvercrest held the property on constructive trust. It wasn't an order. Yeah. It wasn't. I see my lord's point, but if the order had only been directed at the fiduciaries, my lord would be. But the critical thing about that case is that the order was made against Silvercrest.
But the answer to that bit of the conundrum could be that this was all something that was possible under the very wide jurisdiction the court has on unfair prejudice petitions, not necessarily what would follow as a matter of pure trust law.
Well, my lord, that's the way my learned friend puts it. But
what is
to which I would say, well, in that case, why is it being? I asked rhetorically, why is it being referred? Yes. Why is it being relied on and approved in a trust case? I mean, if the answer is it's only about unfair prejudice, then it would seem to have no relevance, really.
Huh. Yeah.
And then I just ask you to go on to. I think this was my learned friend's markup, but I refer you to it. Paragraphs 57 to 59. If I could just ask you to read those. I rely on, again, on Lord Justice Lewison's reliance on Buller and Cook and Deeks at the foot of, at the bottom of paragraph 57. The explanation which is sometimes given, which is an opportunity belongs in equity to the company, is just sort of equitable shorthand. I mean, of course, I accept that an opportunity doesn't have the characteristics of property. It's not something you can sell. It doesn't have permanence. It's not exclusive. I see all of those things, but it has provided a basis for a foundation of a knowing receipt claim. So if a director diverts an opportunity, it provides a justification for attaching liability to the knowing recipient.
Well, I mean, I know you say that. I'm not saying it's wrong necessarily, but can you show us a case where an opportunity which hasn't matured into a contract has been held to found a knowing receipt claim?
Sorry, do you mean? Sorry, may I just ask, does your lordship mean matured into a contract before
the receipt that one is seeking to rely upon?
At the risk of sounding like a stuck record, yes, Buller.
Yes, all right.
And so those were the parts of the Court of Appeal decision I wanted to refer you to. If I can just take you to the Supreme Court decision. As I flagged a little earlier, quite a lot of this is also relevant to equitable compensation, but perhaps I could deal with it now so we don't have to go back to FHR later. Lord Neuberger gave the lead judgment. Paragraph 1, he explains the issue. Sorry, page 1857. This is the judgment of the court on the issue of whether a bribe or secret commission received by an agent is held by the agent on trust for his principal, or whether the principal merely has a claim for equitable compensation in a sum equal to the value of the bribe or commission. So the court is proceeding on the premise that there is at least a personal remedy for equitable compensation, and that's nothing to do with loss. And then if you could go to paragraph 6, the first sentence, another well-established principle which applies where an agent receives a benefit in breach of his fiduciary duty, as that the agent is obliged to account to the principal for such a benefit and to pay in effect a sum equal to the profit by way of equitable compensation. So this shows the breadth of the remedy of equitable compensation, not just about loss. And then I won't read it, I'm not going to read it all out, but if I could just ask you to read paragraph 7, again I rely on that heavily when we get to it for the purposes of equitable compensation. Again, equitable compensation is restorative rather than compensatory. Nothing to do with loss to the principal. And then if I could ask you to turn to paragraphs 14, our friends Cook and Deeks and Buller are cited with approval again. You see here that the Lord Neuberger does. I have to be careful how I put this. I can't go any further than this, but certainly Lord Neuberger did not appear to attach significance to the precise sequence of events. So when he refers to Cook and Deeks, he talks about a company formed by the directors was held to have entered into a contract. On an ordinary reading, it suggests that Lord Neuberger's view was it was the Dominion Construction Company which entered into the contract. It wasn't a two-stage process.
Yes, but his description at paragraph 14 raises all sorts of questions, doesn't it? Because he says, company formed by the directors was held to have entered into a contract on behalf of the original company of which they were directors, because, he uses as, the directors only knew of the contractual opportunity by virtue of their directorship. So lots of questions about that.
Yes. And then Lord Neuberger refers to Buller and just says it's effective. It's the same facts as Cook and Deeks, save that it was a piece of real property rather than a contract.
And we have the problem, all this is part of the scene setting, and it's obviously done in a fairly compressed manner. It wouldn't have been appropriate for the court to begin a detailed analysis of the facts.
No, and that's why I say, that's why
I'm really wondering, of course, when you're entitled to show it to us for what it's worth, but the answer is maybe it doesn't take us very much further.
so be it. I said I can't go further. There's a limit to what I can properly say, but I mean certainly there is nothing here which, there's, albeit it was scene setting, it doesn't appear to have occurred to the Supreme Court to spell out whether it was 2 stages or 1 stage. I'll now take you to Buller and Buller. I keep promising that. It's Authorities, Bundle 1, tab 23. This was...
Hey, could you just hang on a minute, Mr. Shaw? I've got a rogue file, and I have to keep reconstructing it, I'm afraid, before I can close it, so... Sorry. Sorry, number 1.
Sorry, yes, Authorities 1, tab this. These were unfair prejudice proceedings. Lots of different allegations, but the one that I focus on is the allegation that an opportunity to purchase a piece of real property was diverted from was diverted by the directors to their company Silvercrest. If I could ask you please to read the highlighted parts of the head note. So, to Sir Launcelot's question, you see that the relief was granted against Silvercrest. It wasn't just a remedy granted against the directors.
But they were also ordered to procure the transfer.
Yes. And then, if I could ask...
And I think I read, sorry to interrupt you, Mr. Shaw, I think I read that Silvercrest hadn't been a party, and that in order to make good the order, counsel also was instructed on behalf of Silvercrest. So it was all being seen through the lens of the behaviour of the directors, and then in order to achieve the proper outcome, an order was made against Silvercrest, and Silvercrest, which was not before the court, was represented in that way.
That is correct, and it's dealt with, my lady, at paragraph 4.
Thank you. I'm sure I've read it somewhere.
That's where you've picked up the. You're right. Silvercrest was not originally a party. I say I wasn't involved in the case, but I think the context was this. As always in unfair prejudice proceedings, what the minority shareholder wanted was a buyout. The court wasn't prepared to grant a buyout, so the remedy was less drastic. And that's what led to the declaration and Silvercrest being joined. The judge declared Silvercrest holds the property on trust to the company. He ordered the appellants to procure the transfer of the property to the old co at the price which it was paid. He directed an account of profit. And then the question on appeal was whether that was justified, and what the appellants said, it really is. It mirrors what my learned friend says today. It was the pre-existing property point that was advanced. It was said that there was no. It wasn't appropriate to declare the property on constructive trust because it wasn't pre-existing trust property, and you see that from paragraph 20. And so what Mr. Berrigan for the appellant said is that a director is under no duty to offer to the company business opportunities which come to him privately, notwithstanding the company may be in a position to exploit those opportunities. And then he relied on Lord Justice Millett's analysis in Paragon Finance. Now, we've got those cases in the authorities bundle, but I don't propose to take you to them. The question of whether there is pre-existing trust property is very relevant to limitation. This is Lord Millett's distinction between Class 1 and Class 2 trusts. But the present case is not about limitation, or it no longer is about limitation. There's no appeal in relation to limitation here. So I will accept that for the purposes of applying Section 21 of the Limitation Act, it is necessary to ask whether a fiduciary acts in breach of duty in relation to pre-existing trust property. But that's not what we're dealing with here, and it wasn't what the Court of Appeal was dealing with in Buller. And then if you go to the conclusions at 27, the court rejected Mr. Berrigan's submissions that there needs to be pre-existing trust property. So at 28, the question is not whether the party to whom the duty is owed has some kind of beneficial interest in the opportunity. It's too formalistic and restrictive an approach. The question is simply whether the fiduciary's exploitation of the opportunity attracts the no conflicts rule.
So, I mean, for better or for worse, the focus is there squarely on the fiduciary who has put himself into a position of conflict.
Yes.
And on the face of it, you might think, therefore, that it's really relief. What we're looking at here is an aspect of the relief against the errant fiduciary. And it's in that context we say, well, actually, the property ended up in the hands of Silvercrest. And as part of really providing effective relief against the director, we must ensure that Silvercrest disgorges this property.
Oh, my lord, I would accept some of that, but respectfully wouldn't accept all of it, because I think the difficulty with that is that, as referred to in paragraph 4 of the judgment, there was a declaration that the property was held on constructive trust, and we know that isn't just a discretionary remedy, that's an institutional trust. And so it can't be the case that a constructive trusteeship within the confines of unfair prejudice means something different. That was an institutional trust, and what the court has found is that it was appropriate to make that declaration as against Silvercrest. And so there must have been, I mean, I've dealt with this in my skeleton, but I say it's an inescapable conclusion that the court must have been satisfied that there was a proper basis for making that declaration against Silvercrest as knowing recipient. And what my learned friend will say is, well, those magic words knowing receipt are not used, and that's true. I have to accept that. But I mean, that can be the only basis upon which the Court of Appeal upheld the judge's order, the judge's declaration, that the property was held on constructive trust.
So in paragraph 5, the appeal relates only to the relief granted in respect of the purchase of the property. There's no cross appeal against the judge's refusal to grant the primary relief sought on the petition. Can you just tell me what the primary relief was?
Yes, I said, I surmised it was a buyout. Yes, it's at page 418, and it's in the head note at E. M's family presented a petition seeking primarily an order for the shares held by the S's family to be sold. So actually, it was the reverse. It's the usual relief the petitioner seeks is an order that his shares be bought out by the majority. But here, it was the reverse relief which was being sought. The petitioners were saying to the respondents, "You sell to us."
One of the things that we see in this judgment is how fact-specific these matters become. Jonathan Parker, LJ, on several occasions refers to the facts of the particular cases, and in paragraph 40, I turn then to the facts of the instant case.
Yes,
But you're seeking to draw a principle from this. I mean,
yes,
what both Lord Newberger and Jonathan Parker, LJ, and in fact, I think the Master of the Rolls, Etherington, LJ, make clear is that there's so many authorities going in so many different ways that one has to be very careful to be conscious of the facts.
I mean, in a sense, yes, of course. But I do say that I mean, the facts of the present case are actually remarkably similar to this, because if you see what the director said, what he said in Inderjit, I think his name is, except in cross-examination, it would have been worthwhile for the company to have acquired the property.
Sorry, are you looking at Bullen?
Sorry, I'm looking it's the middle of.
Thank you. Sorry.
Between D and E.
Yeah.
The director accepted it would have been worthwhile for the company to have acquired the property. The reasons why it would have been worthwhile were not explored in evidence. Well, you will have seen that from the liability judgment, Mr. Monks accepted that the opportunity to build a business at the site was a real opportunity. I mean, he conceded that.
Yes, although, well, it wasn't something that GBR would be unaware of. They were the owners of the site, weren't they?
No. The site was owned by another company called Greenbox.
Yes.
Greenbox, GAL, Greenbox Assets Limited.
Yes.
It was then sold. The freehold was sold by receivers appointed by JL's bank. The freehold was sold in June 2011 to a company called Benchmark.
Yes, sorry. Going back into Buller, what in paragraph 41 is said is that the company, that is this company that was in the midst of breaking up, would have benefited from knowing the information that the directors had effectively secreted and put into Silvercrest. And Jonathan Parker, LJ, makes the point that one of the directors obviously considered it to be a conflict of interest.
But I mean, in a sense, I think the point is water under the bridge. But I don't think my learned friend ever advanced this argument. I think he was right not to. But I don't think it was ever said that Mr. Monk's knowledge should be attributed to GBR, so that GBR should be taken to have known of the diversion. What Mr. Johnson found is that Mr. Davies, the majority shareholder, was kept in the dark, and you've seen Mr. Johnson's findings about that.
Yes. You also found that. Sorry, this is probably a very simplistic question. You also found that there came a stage where the duties of Mr. Monk to GBR effectively came to an end because there was no entity to which he owed the fiduciary duty.
Yes.
So it's not exactly on all fours with Buller, is it? Where there was a continuing fiduciary duty between the directors of Silvercrest and the family company, which was effectively being wound up.
Well, until on the 18th of October 2011, that's the date that GBR was struck off and dissolved the register. I had a go at persuading Mr. Justice Johnson that upon the statutory restoration,
he wasn't having it.
He wasn't having it.
No.
So I would have made my life easier, but there we are. So Mr. Monk's duties came to an end on the 18th of October 2011. But what I do say is that at that point, everything which GBRK had ought to have been owned by GBR. So everything GBRK held,
Isn't that what Mr. Holland found? Which is why he gave a 0.8 million
He
award.
didn't. No, I think he rejected my argument that the whole of GBRK's property was held on constructive trust for GBR on the 18th of October 2011. But that was because he regarded my claim to relief as restricted to paragraph 272 matters,
which we've already gone
which
through.
we'd been through,
Yeah.
and he also he didn't accept my point about you don't need pre-existing trust property. So no, he didn't accept that everything held by GBRK on the 18th of October was held on constructive trust for GBR.
And on that particular date, Mr. Shaw, I know that you take exception with the date. That's clear from your submissions. I'm still struggling a bit to know what it was that GBRK did own, because the liability judgment seems to suggest that it was not much.
Well, I mean, I don't think there's ever been. I mean, what GBRK had was a trading business, and so I don't want to trespass on my learned friend's cross appeal, but what Mr. Holland found.
Well, you do.
Well, okay, I
Because you're
do, but not.
responding.
I don't. But in fairness to him, I shouldn't do it now, probably. But what Mr. Holland found, and we obviously say he was right to find this, was that the trading business which GBRK had was worth 0.8 million on the 18th of October 2011. And you've seen that essentially turns on whether the equity investment. So, I mean, GBRK had when we talk about a business is shorthand for the portfolio of assets which make up which one needs to trade. So, skips, plant, machinery, etc.
But the experts had gone through that and said, well, there were obviously two different takes on what the company was worth. But there was the issue of effective cash flow insolvency, wasn't there? Because
well, again, I think there's a dispute between us as to quite what the judge found. I say it was only cash flow insolvency. My learned friend says that on a fair reading of Mr. Holland's judgment, he was finding both balance sheet insolvency and cash flow insolvency.
So if Mr. Cook's right, what was it then that Mr. Holland didn't hand over to you?
Well, what he didn't hand over was the profit, the income which GBRK was able to generate after the 18th of October.
So it's the date again.
Yeah,
The cut-off point.
Yes, it is. It's where you
all
draw
goes
the
back to
line.
this cut-off.
It's all about where you draw the line, and in simple terms, the essence of this appeal is that the line was drawn too early.
Yes, understand that. So
It's
if
all
he
about,
was-
sorry,
no,
2011
please.
to 2015. I'm sorry to interrupt.
No.
Yes.
Yes.
So if he was right about that 2011 date, you're done for. GBRK, you're done for.
Well, as regards the claim against Mr. Monks, that must be right. But Mr. Holland let GBRK off completely.
Yeah.
I say there's very little I can say at the moment about cost, but certainly, one can see that if your lordship allowed the appeal, even to this extent, that GBRK was made jointly and severally liable to pay the same sum, that would have a bearing on costs.
Right, okay. So if they were jointly and severally liable, and the award was 0.8 million less any account that has to be made, and I know that's part of your appeal further down the line. And Mr. Monks pays what's due. In just 2 or 3 sentences, why would it make a difference as to costs?
Well, my lady, I need to be. I probably shouldn't say more than I have. Lord Justice Newey has made an order requiring redaction.
Right.
So
Okay.
I'm afraid I really shouldn't say more than just to flag
you'll be
there is
getting
a potential cost if the outcome of your decision
All right.
on substantive point.
All
yes.
right.
perilous waters.
Could we just go back to Buller very quickly? And I know we're taking up a lot of time, but in the judgment of Lord Justice Parker, there is no direct reference, is there, to the trust remedy? It's all through the lens, and if there is, I'd just be grateful if you show me where it is. It all seems to be through the lens of the breach of fiduciary duty by the trustees, the directors, in purchasing a property through Silvercrest. And you get that at 18, for example. And you get it also in the focus of 27 and 28. It's the exploitation of an opportunity by a fiduciary and the fact that they've popped it into Silvercrest. And that's, I think, the same and the focus at 41. And at 42, you're looking at conflict. It's the conflict of duty. And I can't find anywhere, although, as you say, they therefore endorse the order of the judge, I can't see any reference specifically to that. Am I blind?
No, my lady, I do have to accept that.
Yeah.
That's why.
No, I'm not. This is no test or.
No,
It's just I just wondered whether I missed it.
No. I mean, if you like, that's going to be my learned friend's best point. To say, well, it doesn't say in terms. This is all about.
I just wondered whether I'd missed it. That's all, Mr. Shaw. Thank you.
We've got 10 minutes to lunch. I'll take you now to Cook and Deeks, if I may, which is obviously the other case I flagged when we were looking at FHR. Tab 3 of the same bundle. I've already said quite a lot about this case. This is probably the classic business diversion case. The 3 directors of the Toronto Construction Company diverted a railway construction contract to the Dominion Construction Company. There is a degree of ambiguity in this report as to whether it's a 2-stage diversion or a 1-stage diversion. So in other words, did the directors take the contract themselves and then put it into DCC, or did it go straight to DCC? If I can just show you the relevant parts of the judgment which deal with the facts. So we pick it up at page 26, going over to 27. So the directors knew they had obtained the contract for themselves. They failed to tell the plaintiff. So they then first informed the plaintiff. He didn't protest. The DCC was formed.
It says he protested without result, rather than he didn't protest.
Sorry, I meant to correct myself. Yes, he protested without result. And then the defendants, the directors formed the DCC. And then there's this sentence which causes trouble. It's the final sentence. The contract was accordingly taken over by this company, by whom the work was carried out and the profits were made.
Of course, it is very opaque, and we've been here in FHR and in the judgment of Lord Justice Lewison in the same way. But if you start at at 26 again, at the beginning of that last paragraph at the bottom of the page, it's that a necessary appropriation for the contract had been made and communicated to Deeks and Ramsey, who said they might proceed with the contract at once. As from this point, although a formal contract was not signed, the defendants became certain of their position and knew they had obtained the contract for themselves. So there's that confusion there about what that really means at that stage. But there's the suggestion that it's they've secured something for themselves as individuals, perhaps.
Yes.
And then they form their company, and the contract is taken on by their company. It's the same point which was described by Lord Justice Lewison as winning a tender or whatever.
Yes, although I mean, if my lady is putting to me that on a fair reading of the report, the directors sort of entered into the contract themselves, I certainly would dispute that. I mean, it looks as if maybe they got to there was a sort of maybe they won the tender.
Yeah, and that's the way Lord Justice Lewison describes it. And I'm just linking that up with this paragraph about necessary appropriation, and they knew they'd obtained it for themselves.
And then I'm not sure it helps much, but I should show you. If you go to 29, again, a rather opaque paragraph. Their lordships think that. And then at page 30, the paragraph that I've highlighted. I mean, this is direct. These comments are directed at the directors. The directors could not retain the benefit of it being a contract for themselves. Then it belonged in equity to the company and ought to have been dealt with as an asset of the company. It may be said against me that this is an indication that that this is the two-stage process. The directors took the contract and then put it into dominion. But I would dispute that. I mean, again, it's not clear. And what the Privy Council was dealing with here, it wasn't. This was a description of. This is an application of the Keach and Sanford principle that fiduciaries can't take themselves benefits. That's what this was getting at. And then and then finally, page 30 over the page 31. You see, this is where the board directed an account of profit against not just the directors, but DCC.
And it's knowledgeable receipt again.
Yes. And so this is a sort of relatively old case now, but I rely on this because here you have a knowing recipient. At least on one reading, one perfectly sort of reasonable, sensible reading of this judgment, it was a new contract. And the board ordered the DCC to account for profits which it had made. I mean, again, I've accepted a number of times, there is ambiguity here, but certainly what one can say is that the board doesn't seem to have been troubled about the precise sequence. It doesn't appear that DCC's liability to account for profits turned on the happenstance that the directors took the contract first and then handed it over.
The respondents in the Privy Council were the defendants. The directors. It wasn't the company. And are we therefore to take anything from the fact that it's and the account must be directed in form of as an account in favour of the Toronto company against all the other defendants? Is there anything to be divined from that?
Well, 2 points, I think, my lady. I mean, the first one, sort of the one I rely on, is the fact that it's clear the account was ordered against DCC as well as the directors, but it's not relevant for the purposes of this appeal. But those words have given rise. Sorry, let me recall. Yes, it's in ultra frame. There's a question of whether. If a director diverts business, whether if the court orders an account of profits against the director personally, whether the director might also be required to account for the profits that the company made. So that doesn't arise in this case, but there has certainly been debate in the cases about whether this authority stands for the proposition that the directors they weren't just liable for the profits they've made themselves, they were also liable for the profits made by DCC.
Because they were one and the same.
Well, yes, that's how the argument goes.
What, yours or?
But I mean, it doesn't arise here.
Yours or Mr. Cook's? That's the way the argument goes. Is it your argument or Mr. Cook's?
Well, so it doesn't arise in this case because I haven't sought an account of profit against Mr. Monks. So the point just doesn't arise here. But so I was just trying, just by way of an academic aside, I was just trying to. Your ladyship asked me whether there's any significance to those words. I think that's the significance.
I have just noticed, and I think I ought to just bring it to your attention to raise and perhaps dash down. But if you look on page 21, in the beginning of the head note, it says the action was brought in the High Court Division of the Supreme Court of Ontario. If you see where I am.
Yes.
1, 2, 3, 4 lines down, it's saying who the respondents were: Deeks, Hines, and the DCC company, for a declaration that the respondents were trustees for the Toronto Construction Company of the benefit of a contract dated the 1st of April 1912 made between the individual respondents and the Canadian Pacific Railway Company. And I just wondered whether that shed any light on anything, despite the fact that it's only in a head.
Well, my lady, I'm grateful for you to draw it to my attention. I mean, I think my responsibility, I'm not sure it advances things very much.
I just thought it was worth mentioning.
Yeah. So where are you at 1 o'clock, Mr. Shaw?
I think you've been chivying me along, for which I'm grateful. I think ground C, there's really very little to say about that. The two sort of big points were knowing receipt and whether you need pre-existing trust property, and the other one is equitable compensation. I've said quite a lot about that already in the context of FHR. So no, I mean I would hope. I certainly will be done this afternoon.
Okay, all right. So we'll be able to close our authorities on Cook and Deach, will we?
Yes, you will. Yes, I will deal just after the short adjournment. I should deal very quickly with the cases my learned friend relies on, which go the other way.
Yeah. Okay. All right. So 2 o'clock. Thank you.